Okay, so one last question, and then we're going to wrap up. Okay, do you remember how I asked you, why is it that affidavit evidence for procedural motions are more lax than...
Because you can't put people on the stand and ask them, and the judge isn't going to make final determinations about motivation, and all the judge is doing is trying to get to some place that'll let them set up what's in the best interest of the children on a temporary basis.
A temporary basis, okay. So then I went away and I thought, oh, that makes a lot of sense. And then I thought some more, and now I have even more trouble because I know in the family law that this is quite different from civil litigation. Just because in family law, you could have a trial, you could, resolve some of the issues, right, in the trials or whatever, and you think you're done, right? But no. Because I heard that in family law, there's such a thing called a motion to change or a motion to vary, depending on change.
Yeah, but a motion to change is once you've had a final order made.
Yeah.
And life happens, changes go on.
Yeah.
And you have to go back to court. Now, again, if you've gone through a trial,
yeah,
and the issues are a divorce is granted.
Yeah.
There's an equalization payment ordered.
Yeah. Yeah.
There's a parenting order made.
Yeah. Yeah.
And there's child support and there's spousal support.
Right.
That's final order.
Final order, right.
Okay. Divorce being granted.
Right.
You can't go back on that on a motion to change. You either appeal it because you say the divorce should be granted,
okay, right,
or the divorce is done.
Right.
Equalization of property.
Right.
It's a fixation by the judge as to what the judge found one party owed to the other on the date of separation. It's a final judgment. The money is ordered. Right. And it's either paid or it's not paid. If it's not paid, you can enforce it.
Right.
If you don't like the amount the judge says is ordered on the equalization payment, you can appeal it. But if you don't appeal it within the relevant time period, it's a final order. You're done. The court's not going to go back and recalculate an equalization payment.
Right.
The only way they can do that is on an appeal. But when you're talking about things relating to spousal support, child support, or parenting,
right,
situations are going to change.
That's right.
Both of you are going to have employment changes. Maybe you're going to have income changes. One of the parties' health may take a nosedive.
That's right.
It may turn 17 and move out of living with mom and move in with his girlfriend. And even though he's no longer 18, no longer in attendance at school, has told both of his parents to F off and die. That's a change in circumstance. So for things like dealing with support or parenting,
right,
if situation changes and things will change over time, then either party can go back to court to say, okay, the circumstances, what's happening with the kids has changed because the kids are growing up or their situation has changed. One of the things that might have been in there was one of the special expenses that dad was ordered to pay every month was daycare. Well, the kids are in grade 12 now.
Oh, right, yeah.
So
no, that's straightforward.
There should be no order for daycare. So you got to change on your motion. Unless your order actually says, unless the order specifically says this is required until this happens at a future date, and then at which point this will be what will happen. Yeah. If the order doesn't say that, if you have to go back to court to change spousal support, child support, or parenting time, then you do a motion to change. So there's some things you can't do.
Right. So my question is, for these motions to change, these are not interlocutory in my head.
No, a motion to change is, it's just a means, they call it a motion to change, but it's basic. Okay, it's done. They call it a motion to change because if it was an application, starting with a whole brand new thing, the court would have to open a whole new court file.
Right. Okay. So it's not
the same jurisdiction. If it's happening, if it's moved from one court jurisdiction to another where the matter is being heard, then you obviously have to do it anyway. But a lot of it was just done for the sake of keeping sanity in the court filing system. Once a matter has gone to court and you've got two parties named as an applicant and a respondent, and all their issues are resolved by way of a final matter, anything that you can deal with because the situation has changed afterwards, if you said it was going to be by application, the rules require a whole new court file to be opened.
Right.
And the parties might even flip around and everything else. Or you could end up with multiple files with the same applicant and the respondent every time they come back to court to change things. So rather than making it a brand new court proceeding, they said it's basically going to continue in the same court file, but you're asking to change the terms of the final order. So that's why it's a motion to change, not a brand new application.
So for the affidavits for these motions to change, would it then it shouldn't be so lax then, because you are talking about changing a final order, right?
Okay,
Changing
but
an
on a
order.
motion to change, you are changing final order, so it's
Yeah.
not an interlocutory
It's
motion.
not into, so with the
No,
affidavit,
it's like the equivalent of an application. They only
yeah,
call it a
so
motion, so they don't have to open a whole new court file.
right,
But
but
it's
that's
all
what
new.
I'm just wondering if the hearsay rule should be just as stringent
They
as.
are. On a motion to change,
Oh, they are,
expected to
right,
follow exactly the same rules as far as hearsay
For-
evidence
for-
is concerned as you would on an application.
right, or trial. I guess that's why I'm kind of thinking like
Well,
the trial for the
a trial
application.
can happen in a motion to change, a trial can happen in an application.
Oh, okay.
So it's an application.
Okay,
So when you first bring somebody to court and you start a proceeding, it's on an application.
right,
If you have to go back to change a final order made on an application, then you
Right.
do have a motion to change. But then a motion to change is considered a whole new proceeding. You've got documents that you have to serve and file at the outset. You either work out a consent to what is going to be what you're asking for or not. If there's no order made on consent, then you go through the same process you do as with an application. You go through your first appearance, you go through case conference, settlement conference, trial management conference. And if you can't settle,
wow.
you eventually go to trial. And if you know this is going to be a long, dragged out proceeding and you've had your case conference on your motion to change and you still have outstanding issues, but you need something changed right away, you can bring a motion for interlocutory relief within your motion to change.
That is so fair, because I understand where the disconnect is, because I'm coming from a civil litigation, background, and so
Motions are always interlocutory.
yeah. But when you call that motion to change, it doesn't sound very interlocutory to me,
It's
because
not. It's not. Like I said, the
something
only reason
else
they call it a motion
on
to
it.
change is because it's not.
Oh,
It's going to happen. It'll be the same file number as the original application. There might be
yeah,
an extension added to it, or there might not. The parties are going to be the same
yeah.
as they were in the original proceeding and named in the same order. So it's a way of the court keeping
Interesting.
all the history between two parties that are coming to court and involving the same kids,
Right.
keeping it all together in the one court file.
That's
So
yeah.
they don't start a separate court file with by doing another application. That's the whole reason they decided to call this a motion to change, because you're going back into the same court file
Right.
where the final order has been made. But other than that, it's like an originating process. You're saying, oh, this is the status quo, this is the final order. Now we're going through an application process to change that final order. And
Okay, I understand. Motion to
in family
change.
law, there's two senses in which the word motion. One is a motion to change.
Yeah.
It's under Rule 15. It's a term of art. It's a very specific term
Okay.
to avoid a party having to start a whole new application. So if you have a 15 motion to change,
Right.
it's basically you're starting a new court proceeding, but it's all the parties and the court file number and everything else are going to stay the same as they were in the original proceeding.
I
But
get
even
it.
whether you're on an application or a
Yeah.
motion to change, if you need to ask for interlocutory relief, you do it by way of an interlocutory or interim motion. So in that way, motions are used the same way in family law as they are in civil proceeding. It's just we've got that one special exception where they use the word motion.
Exactly.
Okay, there's a really good thing that's put out by Luke's Place.
Oh, okay, Luke's Place. Yeah.
If you just look up motion to change Ontario, Luke's Place, it'll actually give you a really good description on what is a motion to change, what your documents are, what circumstances need to exist, what happens when you're looking with kids, blah, 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 blah. Luke's Place, it's a women's shelter.
Oh, okay. So
Very, very well respected and long history one in Toronto.
Okay, so thank you so much, Helena, for sharing your expertise with us again. You always amaze me with. I always learn something new, and today with the motion to change, that's definitely something I didn't realize. Yeah, you think you know something and then you don't. And thanks everyone for watching. If you're new to the channel, don't forget to hit the subscribe button, and then we'll see you in the next video. Bye.
Take care. Thanks, Heather. Bye.